This is Barry Zalma speaking for Claims School Incorporated's blog, Zalma on Insurance. Today we're going to speak about what happens when you sue in the name of the government and the court finds that there was no injury, no violation of the False Claims Act, and no conspiracy. A lawyer referral company's key tam suit against multiple insurers for violating federal law protecting Medicare failed. If Medicare is not defrauded when insurers do not violate the False Claims Act, there's just no action that can be maintained. Key tam Relators, MSP WB, LLC and Michael Angelo sued 316 private insurers and an insurance industry service provider, the Insurance Services Office, Inc., purportedly on behalf of the United States of America and several states. Relators allege that the defendants had engaged in a scheme to defraud Medicare and Medicaid in violation of the False Claims Act and related state false claims acts. The district court granted the insurers' motion to dismiss. In United States of America, Referral, State of Michigan, et al., and several others, the United States Court of Appeal for the Sixth Circuit on January 15, 2025, resolved the dispute. In the past, Medicare paid first as the primary payer, while the private insurer would take care of the rest as the secondary payer. The Medicare Secondary Payer Act of 1980 flipped those rules, making the private insurer the primary payer and Medicare or a non-governmental Medicare Advantage Organization the secondary payer. Even though Medicare is the secondary payer, Congress authorized Medicare to pay expenses up front when the primary payer does not promptly meet its obligations, so long as the primary payer eventually reimburses Medicare for any amounts it overpaid. This might happen, for example, when the primary payer is contesting its liability to cover an incurred expense. Congress also has created reporting requirements to cut down on fraud and assist with the coordination of benefits. Relator Michael Angelo owns and operates a lawyer referral service as well as healthcare facilities nationwide, including a medical transportation company, radiology clinics, a pharmacy, and a surgery center. On behalf of the United States and several states, Relators filed the key tam action against those 316 private insurers and ISO. Relators claimed that the defendants engaged in a scheme to defraud the Medicare and Medicaid programs, asserting reverse False Claims Act violations. Relators allege that the insurers knowingly made false records or statements in violation of Section 111 in order to decrease or avoid a payment owed to the government or an MAO. The insurer defendants and ISO moved to dismiss. The district court subsequently granted the motion to dismiss in its entirety and denied Relators' motion for leave to file a second amended complaint. The Relators, of course, appealed. A reverse FCA claim is one in which the person knowingly makes, uses, or causes to be made or use of false record or statement material to an obligation to pay or transmit money or property to the government, or knowingly conceals or knowingly and improperly avoids or decreases in obligation to pay or transmit money or property to the government. In contrast to a prototypical FCA claim, which penalizes a party for falsely obtaining money from the government, a reverse FCA claim is premised on a party's false or fraudulent effort to avoid a payment to the government. In United States XRL Angelo versus Allstate Insurance Company, the same relators sued numerous private insurers and ISO, raising the same reverse FCA claim based on analogous purported violations failing to comply with Section 111, resulting in underpayment or non-payment to the government. The panel in Allstate concluded that the allegations against Allstate were insufficient to state a reverse FCA claim, and comparing the allegations against these 5 insurers to the allegations made in Allstate showed that they are materially identical in Allstate controls. As in Allstate, the complaint fails to plead with specificity that the insurers were liable for the underlying medical expenses, that Medicare made conditional payments for those expenses, or that the insurers had any obligation to reimburse the government. Allstate requires dismissal of the reverse FCA claim against the insurer defendants, for which the complaint provided specific examples of alleged fraud. Therefore, the district court did not err by dismissing Relator's reverse FCA claim against the insurer defendants. Dismissal of Relator's conspiracy claim was appropriate for 2 reasons. Relators have failed to establish a violation of the FCA, and without an FCA violation, there is no injury and no viable conspiracy claim. And since Relators abandoned any challenge to the district court's decision to deny leave to amend, that was also affirmed. In my opinion, qui tam suits allow a citizen to sue on behalf of the government. They are not designed, nor is it appropriate to file a qui tam suit to profit the relators, although they will share in whatever is recovered if the suit is successful. Since the relators were unable to establish a violation of the False Claims Act, the FCA, without a FCA violation, there was no injury and no viable conspiracy claims. The relators were apparently concerned with the failure of the insurers to pay the claims presented from the relators' health insurance companies and law firm referrals. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. And you can also have access to the more than 4,950 blog postings. Please tell your friends and colleagues about this blog so they can also subscribe. It's free. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing to my Substack publications. Thank you for your attention.